any questions. That should probably be sometime next week. I'm going to turn it over now to our editor-in-chief, Joe Simpson, for a few words.
Sweet 16. Okay. So it's hashtag. This is the 17. I believe 17.
Good morning, everyone, and I'm Joseph Simpson, the editor-in-chief of the Vermont Journal of Environmental Law, and I'd like to welcome you to our symposium entitled TMDL's 2.0 Charting a Course for Clean Water. We've lined up a lot of panelists today who are water quality experts from throughout the country. They'll be covering topics such as the Lake Champlain TMDL, recent TMDL litigation, and the implications that TMDL law will have on water quality in our country moving forward in the future. About 70% of our planet is covered in water, but only about a percentage of that is valuable for drinking. Water pollution poses a major threat to maintaining clean water in our country and elsewhere in the world. And problems such as our rapidly growing Earth's population and droughts due to climate change will only exacerbate the need to maintain clean water in our country. I also want to mention that today is a historical day. For the first time in the satellite era, meteorologists have confirmed that a hurricane has reached 200 miles per hour in the Eastern Pacific Ocean. That's the first time ever in the Eastern Pacific or the Atlantic Ocean that a hurricane has ever been confirmed that strong. And it will likely hit the coast of Mexico today and possibly even strengthen before that. So I just want that to be in all of your minds today. That climate change is real, it's happening right now, and it's not good. So with those things in mind, I'd like to welcome to the stage to keep this conversation going, Professor Mark Latham.
Well, good morning, and welcome today to today's symposium. I obviously haven't had enough coffee, but first I want to thank I have several groups and individuals. First of all, I want to thank VJEL for its planning and preparation for today's symposium. Without the hard work of the members of VJEL, this would not be possible. I also want to thank our faculty for its support and participation. It means a lot to the administration and our students that our faculty is here today. And of course our guest speakers, because without them, who have traveled far and wide, who are here to share their expertise, we could not have this symposium either. And then for all the attendees who are here, we appreciate your presence and the opportunity to learn and question today's panels. The 1972 Federal Water Pollution Control Act, also known as the Clean Water Act, occupies a special place for me. And the reason for that is when I was a brand new associate at a large Chicago law firm, I was a member of the Environmental Practice Group, where we represented the regulated community, right?
The good guys.
Excuse me?
The good guys. The
good guys, right. Or as Pat would probably prefer, I say polluters. But the regulated community. And the very first assignment I had was to research penalties under the Clean Water Act, because the Department of Justice had the audacity to claim that one of our clients was in violation of the Clean Water Act. Along with the Clean Air Act, RCRA, and a few other things. But by far, the Clean Water Act, or the alleged Clean Water Act violations were the most serious. So I had the job of researching penalties. And I should add that the basis of the Department of Justice's allegations was the fact that this particular client, which was a municipal client of ours, had forgot to install secondary treatment on its wastewater treatment plant. And what particularly irked DOJ was this particular publicly owned treatment work received a lot of wastewater flows from chemical plants, including one from Monsanto, and the Department of Justice was particularly upset about sort of this nice orange effluent that our client was contributing to the Mississippi River. If you'd like to know more about this case, I'd love to talk about it, but that's for another day. We eventually did end up settling that. But the settlement was kind of interesting because our client was required to pay a penalty, but then in return, we did receive some significant, or they received significant federal funding through grants and loans that the Clean Water Act provided to upgrade their treatment plan. But the Clean Water Act is, I think, one of our most extraordinary federal environmental statutes for a variety of reasons. It has, for example, Congress brashly declared that it was the objective of the Clean Water Act to maintain and restore the chemical and physical and chemical integrity of our nation's waters, and that by 1985, the discharge of pollutants into navigable waters would no longer occur, which is pretty remarkable when you think about it. So basically what Congress was asserting was that our waterways would no longer serve as open sewers, and as Pat pointed out, the key to this was the so-called NPDES permitting system with the imposition of technology-based effluent limitations on point sources. And I think it's fair to say, I think Pat would agree, and I think you even mentioned this, that the point source program has been fairly successful in dramatically reducing the loadings of pollutants to our waterways. The Clean Water Act also, I think, is extraordinary because it provides for a fairly robust enforcement mechanism as well. There's civil, administrative, and criminal penalties for those who violate the Act. Other important and at the time revolutionary provisions of the Act include the Wetlands Protection program that Section 404 provides, the provisions related to oil spills and the discharge of hazardous substances, and the prohibition and the need to have response plans when that unfortunately does occur. And then, as Pat mentioned too, another key aspect of the Clean Water Act was the grant and loan programs that provided millions and millions of dollars to municipalities so they could upgrade their wastewater treatment plants. But the Clean Water Act, though, is far from perfect, and I think, as Pat also alluded to, too many, or not alluded to, he expressly said, too many of our waters, though, still don't meet water quality standards. And the primary reason for that is due to the failure of the Clean Water Act to take on head-on non-point sources of pollution. And it has taken years of litigation, and as a result of that litigation, today the sleeping giant, as referred to by Ali Hoke of Tulane, is that the sleeping giant known as TMDLs has been resurrected, and that's the focus of today's symposium. So again, thank you for your work in putting this together. Thank you for joining us. I'm confident that we'll all learn a lot today about what is really a cutting-edge aspect of a statute now that is 40 years old, and that's the Clean Water Act. So thank you. Sit back and listen to our wonderful panel. So.
Thank you,